rise. The Court of Appeals, Division 1 is now in session.
Thank you. Please be seated. Good afternoon. This is the time set for oral argument in our cause number IC140034. Mr. Kurth, is it Sventi? Sventi versus Industrial Commission et al. Counsel, we are recording today's proceedings, so when you step to the podium, please identify yourself and the client that you represent. Each side will have 20 minutes for oral argument, and appellant's counsel is responsible for watching the clock and reserving any time for rebuttal that you might desire. We have read the briefs, and we have conferenced the case prior to argument. So with those preliminaries out of the way, Mr. Kurth, you may proceed.
Good afternoon, Your Honors. My name is Dennis Kurth, and I'm with the law firm of Taylor and Associates, and I represent the petitioner, Mr. Sventi. I want to thank you, first of all, for granting oral argument on this case. I don't know if I speak for Lisa, I probably do, but when you have a case like this pending in the Court of Appeals, you tend to ruminate over the case law, especially in a case like this that involves such voluminous case law, and your thinking evolves, and there's different things you want to tell the court when you get up here. But it's a great honor to be here today, and I'm very appreciative that you've granted this. I was speaking with Mrs. Lamont yesterday afternoon because we had resolved the case that was going to be the subject of a hearing this morning, and I told her, I said, Lisa, don't waste a lot of time preparing for the oral argument on this case. It is really not necessary. I said, just try to enjoy the evening with your family. And she promised me that she would, and that she would just wing it here this afternoon. So being a woman of her word, I'm hoping that she keeps her promise. But what I've decided that I want to tell you about this case today is this. In my opinion, it's a significant workers' compensation case. It's a classic textbook workers' compensation exam type question that involves a coverage issue under the arising out of in course of employment section of the statute, the gatekeeper area of the statute. It's a critically important area of the statute, and it is the typical area of the statute where the law is liberally construed, and it's a good opportunity for the courts to liberally construe the law in deciding what type of claims are compensable. There really hasn't been a case like this since the Bergman case in the year 2000. This is very important, and I hope that you agree with me that it's a very significant case. Even though the injury, seems a little bit strange, or perhaps to some of you trivial, where a person is bending over and herniates a disc in a hotel room. But my problem with this case, or my problem with the Industrial Commission ALJ's handling of this case, is twofold. I think that the judge obviously gave this important, significant gatekeeper case fairly short shrift in his awards. There's two problems, in my opinion, with the way the judge applied the law in this case. First of all, he did not apply the correct test to determine if this activity was compensable. In his first decision, he doesn't even mention the continuous coverage rule for a traveling employee or the quantum of work connection test. He entertained very brief memorandum from the parties, and Mrs. Lamont's memorandum said that the injury should be found non-compensable because of the Sachs case. Now, Sachs, of course, was a 1970 appellate opinion about a fixed site worker who herniated a disc arising off a toilet in a personal comfort activity. All the judge said in the very short decision was, I accept the defense memorandum. Then when I filed a request for review with the judge, the respondents then argued something a little bit different, which was it can't be compensable if it was everyday activity, or taking off one's work boots in the hotel room was not incidental to the travel or the work activity. But the judge never, how do you write two decisions and never mention the continuous coverage rule or the quantum of work connection rule on a case like this. The second problem, I think, with the judge's application of the law is that there is a well-known rule of statutory construction in workers' compensation, which is that the law must be liberally construed to benefit the injured worker. Clearly, that didn't happen here. I mean, you can't even tell how the judge construed the law or applied the law, much less liberally. If you were to apply the law liberally, you could not possibly reach this conclusion. As I indicated in the reply brief, from the Post case, the Supreme Court said that there's a certain minimal activity that the judge needs to do, the ALJ at the Industrial Commission. He needs to resolve any conflicts in the evidence. He needs to tell the parties what law he's applying and how he's applying it to the facts to reach the result that he gets. Now, clearly, that didn't happen here. In the Post case, the Supreme Court said that the judge needs to set forth his application of the law to the facts. We must know how the judge reached his or her conclusion. And if we don't, we can set aside the award because judicial review is not possible on the record. So I submit to you, first of all, that I think this case falls directly within that admonishment from the Supreme Court in Post. So those are the two problems I have. I think this case would be a perfect opportunity to set the law straight in this area because in whatever test you apply to this situation, whether you're applying the continuous coverage rule of Bergman or you're applying the quantum of work connection test, this injury ought to be found compensable. Under the continuous coverage rule, there's really not even a question because if you look at the Bergman case, any activity that the injured worker, the traveling employee is doing that's part of the work at the job site or incidental to the travel, any injury that occurs during that activity is compensable except when the person is on a deviation, a personal deviation that would take them out of the course of employment.
But Berman was only a course of employment case, right? It didn't address the arising out of problem.
No, it did address, Judge, it did address the arising out of also. But that brings up an interesting point because I was reading our workers' compensation handbook, and in the chapter that dealt with these type of injuries, Mr. Lundmark, my opposing attorney's partner, wrote the section, and he said, it really depends on how you analyze this issue. Do you analyze this as a course of employment issue, as most of these traveling employee cases are, or do you analyze this as an arising out of issue? But Bergman actually analyzed it from both angles, from a course of employment issue and an arising out of issue, because if you'll recall from reading Bergman, the defense raised the argument that the injured worker had deviated on a personal risky errand of jaywalking across a street, and that's really what caused the injury. So what they were saying was that the injury did not arise out of the employment because the risk was connected to a personal choice to engage in a risky venture of jaywalking across the street. So, that would have analogized it more to the Pottinger, La Tourette, and the other case where the person or the injury to a traveling employee was found not to have arisen out of the employment because the claimant had made a bad personal choice that created the risk that caused the injury. The way I look at it, the continuous coverage rule implicitly covers and has a built-in test for arising out of. The cases like Bergman and Peterson, where the man suffocated with his head between the headboards, they talk about arising out of, even though the basic rule focuses on course and scope of employment. But they talk about arising out of it, and what we learn from what they say about arising out of is that the injury arises out of the employment if the activity that causes the injury is incidental to the employment or the travel. So that's why in Peterson they say the risk of injury was incidental to the travel because he had to stay in a hotel room and sleep in a hotel bed. Same thing with this case. The injured worker had to stay in the hotel room and obviously take off his work boots in the hotel room. So I think the continuous coverage rule incorporates the arising out of element, and I think all we need to prove, and I think Lisa would agree with me, is that the activity that caused the injury was incidental to the travel activity, being in the hotel, just like sleeping would be.
So where does the quantum of work connection fit into your analysis?
Well, it doesn't necessarily fit into my analysis. Now, it fits into the respondent's analysis, and I'll speculate as to why it fits into their analysis, and my speculation is because it's the only way you can really find this injury non-compensable. Because it gives them an opportunity to argue that somehow the risk of this injury was completely personal to the petitioner. That's basically it. If you analyze this case strictly according to the continuous coverage rule, there's really no way you can't find this compensable if you can find injuries that occur in hot tubs or playing basketball or jumping into swimming pools, as have been found compensable. So now the quantum of work connection test, as I said in my reply brief, is a little bit different. The only time it's been applied in the context of a traveling employee was in the case that we've cited here. The name escapes me at the moment, but it was the 1992 case that involved the person going to San Francisco and contracting Lyme disease. I think they applied it there because there was a question of how do you apply the arising out of test where you're talking about a disease, the contraction of a disease that's endemic to the area of travel, but not to the area that you came from. But that's really the only time I've ever seen the quantum of work connection test applied in the context of a traveling employee. But if you take a look at this, I mean, that's why in my brief I said you can find this compensable under either the continuous coverage rule or the quantum of work connection. First of all, the course and scope of employment half of the quantum test is pretty rock solid. I mean, anything that a traveling employee does that's incidental to the actual duties of the job or the travel is completely and continuously within the scope of employment. There's really no possible other argument on that. Now, even though my opponent in her brief said that taking off the work boots in the hotel room is weakly incidental, I assume that it's completely incidental, just like sleeping in a hotel room. So if you look at the first element, the course and scope of employment, the course element, it's rock solid. So then you go to the arising out of element. Now remember, in all these opinions, the courts have said that arising out of means that the activity that caused the risk of injury was incidental to the work or the travel. Clearly, the risk of this injury was incidental to the bending over to take off his work boots in the hotel room. That's the focus of that. Judge, if you look at a couple threads of legal analysis all the way back to the Sachs case. And as I said in my brief, Sachs is an anomaly in the law. Every time you see it cited, it's distinguished and not applied. It's hardly ever applied to deny compensability on a case. And it's not a traveling employee case. It's a fixed site worker case doing nothing but personal comfort activity with an extremely weak arising out of element because there's practically no evidence that there was any significant exertion that caused an injury. So we don't have that problem. We've also got a line of cases starting with Nolan, Farish, Samaritan, all those cases where the court analyzed the compensability of injuries that occurred from very innocuous everyday activity like walking, bending, stooping, and found in all those cases that whether you'll let a pre-existing condition disqualify an injury from compensability is very problematic. And in a situation like this, you would not want to apply, or you would not want to conclude that the arising out of element here in a case like this petitioner is weak. It's actually fairly strong. He had a pre-existing condition, but it was completely quiescent at the time this injury occurred. He was not receiving any treatment for that condition. He had recovered from it, according to the letter from the chiropractor who treated him. It was completely quiescent. And what he did and the exertion that he engaged in, bending over to take off his work boot, was critically important and caused a very, very serious injury, a sequestration of a previously quiescent herniation of a disc that caused the cauda equina syndrome, resulting in the petitioner being brought back by plane in a wheelchair for emergency back surgery. So there is actually a very significant injury here. There's enough of an exertion in the activity to take this out of the SACS analysis and satisfy the arising out of element of a quantum test. So I submit to you that under the quantum analysis, it's also compensable because you have a very strong course of element and you have a strong enough arising element to make it compensable. You might notice when Nolan is looking at SACS in retrospect under the quantum analysis, they say, you know, if the course of element was a little bit stronger in SACS, that exertion of arising off a toilet would probably have been enough to sustain an award for a compensable claim. Your Honors, if you don't mind, I'd like to reserve the rest of my time.
Thank you.
May it please the court, counsel. My name is Lisa Lamont. I'm representing the respondents in this case, Corpro Companies and Liberty Mutual Insurance Group. I want to first address Mr. Kurth's Post versus Industrial Commission argument. To do that, I need to make a brief statement about the facts, very brief, and that essentially here they're undisputed. There were not any factual conflicts that needed to be resolved by the judge. But before we even get to that, I think Mr. Kurth's post argument has to fail for the most important reason, that it wasn't raised on review. As you know, issues need to be raised on review in industrial commission matters in order to give the judge an opportunity to correct their mistakes before they come up here to the Court of Appeals. Nowhere in Mr. Kurth's request for review is post or sufficiency of the findings raised. So it fails for that reason. But even on the merits, this is not a post case. In post, the Supreme Court was concerned because the judge's factual findings were lacking. There was no resolution of conflicting medical testimony and factual testimony, and no way for the Court of Appeals to determine how the judge reached his decision. That's not the case here. The judge, in fact, very similar to Hester versus Industrial Commission, which is not cited in the briefs, but is 178 Arizona 587, a post argument was raised there. And in Hester, like in this case, the judge adopted a memorandum of the party as saying, this is the basis for my decision. That's what the judge did here with respondent's memorandum. The Hester court said there is a sufficient basis to tell why the judge decided the way he did, because he adopted one party's memorandum. And the Hester court went on to say that even if the court rejects the reasons in the memorandum that the judge used to base his award, if there's an alternative theory that supports the award, it should still be affirmed. So on either basis, the sufficiency and the post argument fails. Moving on to the meat of the argument, the course and scope, Mr. Kurth is citing the continuous coverage Bergman precision case. And again, we're not discrediting that applies to the in the course of component, but that does not, it is not dispositive. Yes, the claimant was traveling, and the continuous coverage rule applies to allow him to be in the course of employment. But the arising out of element still needs to be met. It has never been the law, whether it's a traveling employee or a fixed site employee, that as long as they're in the course of employment, everything else is covered. There's a separate arising out of component. There are numerous instances of cases where fixed site employees are within the 4 squares of their actual workday performing work activities, but they're injured for risks that have nothing to do with the employment and are not compensable. So both factors need to be considered. And before I move on to the more, I guess, controversial arising out of the element, I wish to point out that, of course, the quantum of work connection theory applies. Mr. Kerr seems to suggest that that is mutually exclusive with continuous coverage. They're not. The quantum of work connection theory is the balancing of the relative weight of both in the course of and arising out of element is absolutely the standard that should be applied. It's been done in fixed site employee cases. It's been done in traveling employee cases. Whether or not it's called that, that's what this court does, is weigh the relative weight of those components and find whether together they meet the compensable level. So under the quantum of work connection, the courts analyze this as, are these components weakly or strongly met? And yes, the claimant is met in the course of employment because of the Bergman precision case and the traveling employee coverage. But not everyone who meets in the course of meets so strongly. A strong in the course of employment would be a claimant who's injured while actually performing their work duties during the workday. That's a strong in the course of employment. A weaker, necessarily weaker in the course of employment cases are anyone who falls in the course based on some expanded coverage rule, like personal comfort, traveling employees here, exceptions to coming and going, after-hour use of premises. Those are necessarily weaker than someone who's injured while actually performing job duties because there's a step back from an actual work connection. So while the claimant does meet the in course of employment here, we would suggest it's weak. It's weaker than someone who's injured while performing their actual job duties.
It's probably not weaker than Peterson, though, although Peterson didn't reach that issue as I read the decision. Is that accurate?
Yes, Peterson, they assessed it under personal comfort because I think that was prior to Bergman precision being decided. Either way, it's an expanded in the course of I guess, coverage issue. It's not someone who is working. I would argue they're the same. Personal comfort, traveling employees, those are all in the course of, expanded in the course of factors, but not someone who's injured while actually working.
But the connection or the quantum of work connection, in your view, in Peterson would be pretty weak, wouldn't it?
In the course of, yes, but there was a much stronger arising out of element there, which I'll get to, because he was injured by his head getting caught in the slats in the headboard of the hotel room. That's an inherent risk of the hotel room where he was required to stay for work. So there's a much stronger connection under the arising out of being incidental to travel.
Was claimant required to wear boots on site?
There was no evidence of that. He may have been required to wear boots, but there was no evidence that he took his boots off any differently than he would any shoes, loafers, or any other shoe he had to wear, or that he took his shoes off any differently in the hotel room than he would have at home or anywhere else. So I believe he was required to wear boots for work, but again, no indication that played any role in how he took his shoes off in the hotel room that day.
What if you have a hypo, and let's talk about putting footwear on as opposed to taking it off, okay? And instead of in a hotel room getting up before you go out to go to the job site, you work in a white room, and you have our clean room, and you have to have the little sort of footies that go over your shoes, and that's how this injury happens. Would that be a different case? Would that be compensable?
It's a different case for two reasons.
And it clearly is factually. I'm not suggesting anything.
Yeah,
else.
no, it is because some kind of white room, you assume they're on the employer's premises, so they've started their work day or getting ready for
They're in
work.
the lockers. Instead of in
Yeah.
the hotel room, they're in the lockers.
Yeah, most, in the course of, they're on the employer's premises, starting their workday, getting ready for the workday. That's a completely different issue than someone who's a traveling employee. And I would argue that's different too, because the specific requirements they have to go through to get ready to go into the clean room are a requirement of their job. So that's more of a direct job duty than what's going on here.
What if there was a requirement that you had to wear steel-toed shoes?
There's no testimony or evidence here that steel-toed shoes.
I'm asking hypothetically. What if, and that workers typically wore what I called sneakers or tennis shoes to work, but they couldn't go on the floor if they didn't have steel-toed shoes, and the injury occurred changing from tennis shoes to steel-toed shoes.
On the employer's premises, we're assuming?
You tell me.
Yeah. If it is an actual requirement of the job, I think that's a much stronger case. That's not what we have here, though.
And I understand they're different scenarios, and the question is how different.
Well, again, in the course of is much stronger when you're on the employer's premises doing activities such as in Nolan, the person was sitting down in the chair to start the workday. That was an activity they needed to do for work. That's a much stronger case, a much stronger in the course of component than someone just getting ready as anyone would to go to work on any normal day at home or in a hotel room while traveling. I guess moving on to the arising out of component, to say that I think in this case it's met weakly, I think is overly generous. I think the risk of work having any relationship, or sorry, the risk of injury here having any relationship to the work or travel is extremely, virtually non-existent. That's because the petitioner was not injured from any outside risk of work of travel, like a plane crash, anything like that, or any inherent risk in the room where he was required to stay, like head getting caught in the slats, or being cut by a broken mirror, or sitting on a chair in the hotel room that collapses. That's a risk inherent of the room where they're required to stay. This was a normal bodily movement that was completely removed from work or travel, and an injury that could have happened anywhere. When you're dealing, I'm sorry.
How, if at all, Dr. McLean's testimony fits into this issue?
Well, Dr. McLean's testimony is the only medical testimony on causation. Dr. McLean's testimony was that the petitioner had a pre-existing back condition, probably already some herniation, which fully extruded when he bent forward flexion, while trying to kick off a shoe. That's the only medical causation that's present, and that's what we're basing our discussion on.
Does that have anything to do with the quantum of work connection analysis? That's the link I'm trying to find, if there is one.
Under arising out of, yes, it does. It's respondent's contention that when you're dealing with a weaker in the course of element, when a claimant is not injured while performing actual work duties, the risk that injures them, well, first of all, here it's personal. It's a personal risk because he had already a bad back that contributed to it. But there has to be some kind of peculiar increased or positional risk. That's what the traveling employee cases tell us, to connect that risk to the travel to make this claim compensable. Actual risk, what we have here is a claimant who was injured with a normal bodily movement. That's an actual risk, just a risk. That has been accepted as meeting arising out of, but only in cases where the claimant was performing actual work duties. That's Nolan, that's Farish, that's Samaritan Health. In those cases, Nolan, for example, that's the claimant that was injured while sitting down in the work to begin the day. The court there rationalized that was the act of sitting in the chair to get ready for work was necessary for work, and the normal bodily movement as a result would be covered under the arising out of. Samaritan and Farish are employees that had knee injuries while walking, but while in the furtherance of work. And as the court in Farish said, where a specific work activity is part of the claimant's job, the risk of injury from that activity is a risk of the job. So that actual risk analysis, normal bodily movement, has only ever been applied in cases where claimants were actually involved in work duties, so a much stronger in the course of employment, so there's a greater link there. Here, the petitioner was injured from not a risk of work, not a risk of travel, but a risk of living. It is so far removed from his work activities or his travel that there's just not enough connection there to make this a work-related risk.
So just to be clear, it's the just taking off shoes that you say is not a work risk. Doesn't matter that it's boots. Here the action was taking off your shoes.
It was actually just bending forward. He was standing, he bent forward to take off a shoe. It was the forward flexion movement that caused it, a normal bodily movement.
Whether it was work boots or sneakers or loafers or...
Right. There's no evidence that the type of shoe he was required to wear for work caused him to take his shoe off that way versus sitting down or some other method of taking off shoes, or that anything about the hotel room where he was caused him to take off his shoe in that manner. There's nothing tying it into his work activities at all. And as much as Mr. Kurth would like to disparage Sachs, it is still good law. And it is the most analogous situation to what's going on here for three reasons. Both claimants had a weak in the course of element. In Sachs, it was personal comfort. Here, it's traveling employees. Neither of them were involved in actual work activities. Both claimants had pre-existing back issues that contributed to the problem. And finally, both were injured by normal motions of living. The claimant in Sachs, I don't remember if it was sitting down or getting off the toilet, here bending forward to take off a shoe. And as the court in Sachs noted, it's a pre-existing condition brought to an acute state by an everyday motion which could occur anywhere. If you have an injury that can occur anywhere, not and it doesn't take place in terms of normal work activities, it can't arise out of the employment. What is the connection? There is not one. So Sachs is the most analogous situation. It is still good law. Yes, it has been distinguished significantly, but that's because all of these cases are fact specific. They've been distinguished on the facts, not because it's bad law. And I wish to speak briefly to some arguments made in petitioners' briefs citing the Larson's workers' comp treatise, suggesting that almost all jurisdictions accept that preparing for work in a hotel room is part of the employment. That is not what the Larson's treatise suggests. Almost all the cases cited in Larson involve claimants who slip in the bathtub or in the shower while traveling for work, and that's probably a little bit of a stronger case. It might be one of those risks inherent in the hotel room where they're required to stay. But even then, a majority, at least half the cases, reject coverage under that circumstance. So to broadly say that Larson supports this and the majority of jurisdictions supports this is not correct. Petitioner also cited a case out of Texas, Aetna Casualty, which involved, which he said it stands for the proposition that shaving while getting ready for work in a hotel room is covered, and that is not what that case says either. The claimant in Aetna Casualty was actually injured when a drinking glass in the hotel room broke and he was cut by the glass, and that case was also, like Bergman Precision, only analyzed in terms of the in the course of element and not the arising out of element. So when you applying the quantum of work connection theory to all of this, the weighing of both elements, it's weak in the course of because it was not directly related to work activity and was an expanded coverage case. The rising out of is virtually non-existent because there's no connection to the work or travel. This is just, again, a risk of living, not work or travel. Now, to open or to find this claim compensable, I think would do what the Pottinger court counseled against, which is opening up workers' compensation to be general accident and health insurance instead of covering risks of work. And that's, Mr. Kurth mentioned the liberal interpretation of the act, but that's not what the liberal interpretation of the act is meant to do. Again, even though in the course of is satisfied, no dispute about that, it's weak. There's no arising, this is not a risk of employment. It's not a risk of work, it's not a risk of travel, but simply a risk of living. Risks of living have never been covered under workers' compensation and should not be covered under workers' compensation. And unless the court has any other questions, I'll waive my remaining time.
No.
Thank you.
Rebuttal, Mr. Kurth?
Your Honors, I'm afraid to say that she can't be trusted. I thought she was going to wing it up here, but she's very smart, but she's wrong. Let me address, first of all, the issue that you can't consider my post argument. Here's the difference between my post argument and a typical post argument where somebody's arguing that the judge didn't make a particular fact finding. You'll notice that in my reply brief on page 2, the paragraph that I quoted says, from post, although lack of findings on a particular issue does not invalidate an award per se, we will vacate a judge's award if we cannot determine blah, 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 whether it was legally sound or the legal propriety. So I'm not saying that you need to overturn the judge's decision because he failed to make a specific particular factual finding. I'm saying that it doesn't meet this smell test for judicial review that the Supreme Court set forth in post. It's not an issue of requesting an extra particular fact finding. The judge simply didn't set forth the law. And what the judge didn't do about the law that is most objectionable here is, I mean, not only did he not apply the right test at all, but he didn't construe the statute liberally. That's the #1 rule of statutory construction in workers' compensation. So we know that he didn't construe the law.
Aren't those two things, though, a little different? I mean, liberally construing a statute, I understand your point, but the ALJ did tell us which body of law he liked from the competing memoranda that were provided. It makes all of our jobs perhaps a little more challenging to dig into it, chapter and verse, but we know from the decision which brief he liked better with respect to a specific, unique, important area of the law.
You're absolutely right, Judge, and I'm not going to waste my rebuttal time arguing with you on that because you're right. You're right. My position is the law is applied wrong here in this case. This claim should be compensable, first of all, under the continuous coverage rule. You don't need to use the quantum of work connection test if you apply the continuous coverage rule. And because
Best authority for that proposition you just stated.
Bergman, Peterson, Pottinger, any of those cases, you'll notice that in
Don't say what you just said.
Well, but they imply because they have a built-in arising out of test in there. And the fact is that the scope of employment is construed and widened so broadly that it's meant to cover just about anything that happens as long as it's not a personal deviation. And clearly we don't have a personal deviation. Look in Bergman, Your Honor, like I said, it has a built-in analysis of the arising out of element because they talk about risk and a personal risk about jaywalking across the street. Now, you know, the other thing, and before I run out of time, I have to tell you, opposing counsel makes a big deal about this is everyday activity, this is normal living. Well, unfortunately, that line of thinking has been completely discredited. You might look at Nolan. Early in Nolan, the court, if I'm not mistaken, says we took review of this case just to settle the question about whether an injury that occurs during everyday living activities can't be found compensable. And they pretty quickly dispatched the idea that it can't because it was everyday activities. And the idea about an everyday activity in this case being different from bending or walking in Samaritan and Farish being different, here's the big difference for a traveling worker. The fact is, the scope of employment is broadened by the continuous coverage rule so that you're really not arguing about whether walking is an activity of everyday living. You're talking about whether the injury was caused by activity that was incidental to the travel. So you're not focusing on whether the injury occurred just by walking or bending. As I said, the course of employment element becomes much stronger in the traveling worker context because everything except the deviation is within the course of employment. You should only reject this under the quantum theory if you find both elements to be very weak, where you've got one element very strong and another fairly strong. In my opinion, it should be found compensable. Thank you.
Thank you. Thank you both for your presentations. We will take this matter under advisement and issue a ruling in due course. At this time, the court will stand in recess in preparation for our next argument. Thank you.